Good evening, my name is Karen Harding, criminal defence lawyer from New Zealand, and I'm currently representing 30 crew members in relation to wages claims in Admiralty, and I am counsel for 26 of those crew members for the Court of Appeal hearing coming up on the 12th of October 2016 in Wellington. I'd like to take this opportunity just to run through with you with Chapter 6 of my Court of Appeal submissions, which are submissions on public policy considerations. Then we can go on and have further discussions about the nature of this appeal. So we have been discussing in the previous videos, this is video 5, why the Sajo Oyang crew that worked on the sunk vessel Oyang 70 and who worked on the vessel Oyang 77 that were forfeited should be able to apply for relief from forfeiture over the sister ship Oyang 75 worth up to $8 million that is now forfeited to the New Zealand Crown for fishing crimes, while they should have relief from forfeiture of that vessel to have that vessel sold to pay for their outstanding wages. This is because they were paid only $200 per month up to $290 per month for working 20 hours per day, well generally 80 to 20 hours per day, while on call 7 days a week, 24 hours a day for up to 2-year contracts, and they have outstanding wages from December 2007 all the way up to October 2011. Collectively, the amount of wages owing is many millions of dollars, perhaps in the range of $4 to $6 million. Also, in addition to those wages, there is also the cost of prosecutions to be paid out of the vessels, the cost of the investigation for the fishing crimes, and the fines that weren't paid by the captains of those vessels who were Korean officers for the fishing crimes, which also total hundreds of thousands of dollars. So in order for the Oyang fishing crew to get paid, they need relief from forfeiture and to have the crown and the jewel that was forfeited, the Oyang 75, sold to provide them with their wages. Why should this be allowed? Let's discuss Chapter 6 of my submissions, Public Policy Considerations. There are important public policy issues at stake regarding the protection of crew wages when a vessel is lost or destroyed. So Section 28 (1) of the Maritime Transport Act 1994 provides that when a member of the crew of a ship shall not, by any agreement, forfeit his or her lien on the ship or be deprived of any remedy for the recovery of his or her wages, or abandon his or her right to wages in the case of the loss of a ship, or abandon any right that he or she may have to obtain in the nature of salvage. And any stipulation to this effect is void. So this is a section in the Maritime Transport Act that's saying that we've got to protect the fishermen. They can't contract out. They're entitled to the minimum wage for every hour that they've worked, and anything else is really not acceptable, and they can't come to some other agreement otherwise, and the employer or anybody else can't force them to. They can't forfeit their rights to get paid. And they're also protected under the Fishieries Act to get the minimum wage, and the employer is not allowed to contract out of the minimum wage. This leads us to a discussion about maritime lien for crew wages, which we discussed in previous video number 4. So when you haven't been paid, you are entitled to have a maritime lien over any vessel or a sister ship if your vessel sunk. That's a secret charge that basically stays with any vessel that says that vessel can be sold to pay you your wages. The problem is when the vessel gets forfeited to the Crown for fishing crimes, the Crown get the vessel free and clear of any maritime lien or any other mortgages or other debts on the vessel. They just get it free and clear, they just own it with no debt on it, and so the fisherman can't sell a vessel that's forfeited to the Crown. They have to apply for relief from forfeiture under Section 256 and have the court decide if they're entitled to relief, and then the court decides that the vessel can be sold to pay the wages. So a maritime lien is something that's really important. It's something that's of respectable antiquity, as they say, and it's an important feature of maritime law. And they play an important part in determining the priority of claims against the ship, especially if the ship, when it's sold, has a fund that's insufficient to meet all the claimants in full, because then they're paid out on a priority basis. And the underlying principle in the determination of priorities is public policy. A maritime lien for wages ranks as one of the highest classes of maritime liens, and that's based on the principle that commerce would not take place without men-to-man ships and that men will not sign up without a trustworthy security for wages. And this is based on lots of cases that said that, and that's a direct quote, and I refer to page 111 of an article written by now Judge Perkins that was part of his master's thesis back in the day, 1986. The 2006 Code of Practice for Foreign Fishing Crew also demonstrates that Parliament intended that the crew should be paid the minimum wage, and that's in the Fishieries Act as well, stipulated that they must be paid it. And our submission is that the Code of Conduct demonstrates that Parliament could not have intended that when a foreign fishing vessel is lost or destroyed in New Zealand, that the foreign crew should have no means of collecting unpaid wages, even when the other vessels in the employer's fleet have been forfeited. So we're saying, as a matter of public policy, the Crown did not intend foreign fishermen who come here on New Zealand work permits to be deprived of a remedy for getting their wages. That's essentially the end of that chapter, because it had to be edited to stay in with a word count, because you can't exceed so many pages in the Court of Appeal. But basically, to deny on public policy grounds the fishermen to make a claim over a sister ship would be to defeat the Minimum Wage Act and defeat the purpose for why the legislation was amended in 2002 to allow foreign fishermen to make applications for relief from forfeiture. Public policy demands a trustworthy source to pay wages. The trustworthy source must be relief from forfeiture over the sister ships that are forfeited, particularly when vessels like Oyang 70 sank in New Zealand. 6 lives were lost, and there's crews that have not been paid who worked on that vessel. The sister ships Oyang 77 and Oyang 75 were forfeited to the Crown. Oyang 75 is worth an estimated $7.5 to $8 million US, and would be sufficient to pay the wages for the crews that are making a claim under Section 256 who worked on Oyang 70 and Oyang 77 vessels. We demand that the vessel be sold, we demand our right to seek relief from forfeiture, and we demand this right over the forfeited sister ship Oyang 75.